On a buck, please. Very sorry about the bad delay so far. D64. Appreciate everyone's patience. D649405 as Buck versus Rittman. May we have appearances, please?
Good morning, Your Honor. Louis Schneider, 9683, on behalf of Jared Buck. He's the father, Your Honor. He's here in my office. We're both on Blue Jeans.
Very good.
Good morning, Your Honor. Jennifer E. Subar, number 13157, on behalf of Mariah Rittman, who is present.
Okay, now we don't have current orders here. In fact, the parties I don't believe have been to mediation yet. And the mom's filed a motion for custody, sole custody and relocation to Texas and supervised visitation to dad, which is kind of impossible if there's a relocation. But she says that she knew dad was a convicted felon for child endangerment, a 10-year sentence, but she had a child with him and wanted him to be an equal parent in spite of this. She says dad started using cocaine and abusing alcohol, so he checked himself into rehab on July 24th of last year, and while he was in rehab, she took child and moved to El Paso, where she filed a custody case. So she wants to relocate to El Paso, and she wants child support, etc. Dad opposes this. He wants Nevada to assert child custody jurisdiction because this is the home state when both parents filed. And he said Mom took child to Texas with dad. She took child to Texas without dad's knowledge or consent on or about July 24th. Oh, with consent, with consent, but with understanding that there would be a promise to return in August when dad got out of a 30-day rehab, but she didn't come back. So he is saying it was with his consent, but with the understanding that mom would return in August at the end of his rehab. Then mom filed a Texas custody case on December 7th. Dad filed a Nevada custody case on 12/8. Dad, in fact, says not only is he opposed to the relocation, but that he's also opposed to supervised visits, and in fact he should be the main custodian. He says both he and mom were abusing alcohol when things came to a head on July 24th. The difference, he says, is he went to rehab to get clean, but mom, rather than acknowledging and addressing her problems, and from dad's perspective, she just took child and ran off. And he says he's sober now, lives in a 2-bedroom condo in a gated community in Green Valley, close to the school, and he wants mom to pay him support. Now, as far as this emergency child custody jurisdiction, I mean, Nevada was the home state at the time of filing. I assume Nevada should at least assert emergency jurisdiction. This is where everyone initially lived until mom left in late July. At least, so if there is a necessity for a UCCJA conference with Texas as to ongoing or home state jurisdiction, unless Texas has claimed emergency or temporary jurisdiction, some state needs to claim it, and it would seem appropriate that it's Nevada, since everyone agrees mom, dad, and Charlotte, minor child, lived here until mom left in July. And of course, a big operative fact that's in dispute is dad saying he gave his consent, but it was limited to mom returning in August. Mom, I don't know exactly what she's saying. She just said in her motion it was with consent. I guess she's saying he permanently consented. I'm not sure why he would if his rights weren't established yet and it wasn't agreed what he'd receive in terms of custodial or visitation rights. And in fact, mom is now arguing he should have limited and supervised visits. Now, dad does have a felony conviction for child endangerment years ago, but not for this child, and mom decided to have a child with him knowing full knowledge of that after he was released from prison. And she wanted him to be a full and co-equal parent. So we're focusing not on that, something which mom knew about and did not consider important, not important to the point where she wanted him to co-parent on a 50-50 basis. So it really is focused on what's occurred lately or since then. What mom is saying is dad abuses cocaine and alcohol. Dad says I have some chemical dependency problems, but I went to rehab and I'm addressing it and I'm sober. And he's pointing the dirty end of the stick at mom and saying, but she was in this together with me and she's not acknowledging her problem, and I am. So we got a big mess here, obviously. So starting with Mr. Schneider, it's your motion. Go ahead.
It's my motion first, Your Honor.
I'm
My
sorry?
motion was filed first.
I think the motion to relocate was
First.
filed first by the by Mr. Schneider, right?
No, by Ms. Isu.
Oh, you're the I got the names transferred. You're
No, I'm the plaintiff, Your Honor.
I represent Ms. Rittman. She filed the motion to relocate first.
okay. We
Then
have
Mr. Schneider filed the motion a few days later, not,
okay. I have on my papers. They were transposed. Okay, names. Okay.
Thank
I don't
you.
believe
Good.
that's correct.
So,
I
Your
filed
Honor-
the case in Nevada. I opened the case in Nevada. That's
yeah,
my
but it was our motion, so the person that filed the
Whoever
motion
wants.
first, the one that
Well, as
speaks
long as
first.
someone talks first, I don't really care. Okay.
I'll be happy to talk
Okay.
first because it's our motion that was filed first.
Okay.
So in this case, the opposing party did consent for my client and the child to move to El Paso, Texas. He has a very long history of substance abuse. This is not like a one-time thing where he went out and did a couple of lines and had a
Let
good
me ask
night
you
and went
this:
home.
if
This
he
is like an
if he consented to it, what's he doing here, vociferously complaining about?
Well, he has mental health issues, this
Okay.
man, okay? Not only has he done so much
When he
drugs,
consented,
he also,
what
now
was the,
he's
what was the agreement as to what his time would consist of? You can't say he consented and knew she'd asked for
well,
supervision.
here's the thing, Your Honor. When people are under the influence and they're so dependent on drugs, they probably don't think straight. We all know that,
Okay,
right?
let me ask you this then.
They
Is it a
make
valid-
certain arguments.
Okay, we have a critical constitutional right. Is it a valid consent if you're saying, you can't have it both ways. You can't say he consented, and then on the other hand, his brain is completely scrambled, then he lacks.
Listen, here's what I'm
Hold on,
saying. You're asking me
something.
for
I'm asking you a
specific
question.
terms, Your Honor.
Does he have
Here are the facts, okay? Your Honor, here are
I'm
the facts.
asking you a question. Okay, if you don't
What
want
is
to
your
answer
question? What is your question?
Okay, the question.
If you're not
is-
going to let me argue the motion, then why did you ask me to argue the motion? Okay, what is your question? Let me answer it for you. What is the question?
You can just present if you want to, but when I practiced, I always wanted to answer questions. I always wanted to know what's important to the court. I always wanted that opportunity.
What's
If you're
important to you,
interested
Your
in
Honor?
that,
What questions do you want? What were the terms? Okay, let me
yeah,
ask
well, a couple
Mariah.
questions.
Mariah, were there any
Hold on.
specific
A couple
terms?
questions,
Were
okay?
there any?
Okay.
Your Honor, come on. We've been waiting for an hour and a half for the
And I
hearing. Could you please
understand
not
that,
do
I
this?
apologize for that, but that's
Please
not
don't
a-
do this to
that's
us.
not
Let
a
us just make our
justification.
argument.
We're not gonna turn it into the Jerry Springer
We've been here
show.
for an hour and a half waiting. Now you're
Okay,
yelling
and I
at me when I'm arguing
understand
the
that, and I
motion?
apologize for that. That's not an excuse.
Just let Mr.
to
Rawlings
take this
speak
off
for an
the-
hour.
the-
He was
the
talking
run.
gibberish.
Okay.
Now we're arguing the motion and you're interrupting
Okay.
me. Why
Okay,
didn't you interrupt Mr. Rawlings?
Okay, you can, here's what, I'll limit it to 2 questions at this point, because I'm not gonna understand the argument.
Mr.
and you
Rawlings
should-
talked like a monkey for
you
2
should welcome-
hours. We
you
sat
should-
here.
You should welcome the opportunity to answer these 2 questions.
Okay, let me answer what is the
Okay, no,
question?
I'm gonna ask them, then you'll answer them, please. Number 1, can he provide consent on a critical constitutional right involving a child if you're saying his brains are completely scrambled? That's one.
I'm talking about after the
Hold
fact.
on, number 2.
I'm talking about
hold
after
on,
the
now,
fact,
hold
not
on,
at the time that
hold
he
on,
consented.
Hold on! Number 2, or we'll end this in 2 seconds. Okay, number 2, what was the agreement because certainly he didn't agree to relocate and be unsupervised or no visit. So what was the agreement as to what his visitation and custodial time is? I apologize very much for just raising my voice and shouting, and I think if you should do the same, but you're not required to. Now go ahead and answer. Please answer the 2 questions.
I do apologize. Okay, Mariah, was there a specific terms of when he would visit the child? It was after he got sober, right? He would come out and visit. And in fact, he did visit one time. And his mother also visited and stayed at Mariah's house. But there was no set schedule of when he would come out because he has his own problems that he's trying to resolve, which he hasn't resolved. Ongoing issues that went on for years that don't usually get resolved within 30 days of rehab. He then went to a safe. So did I answer your question, or is there more, Mariah, about any terms?
I indicated as long as you were quiet long enough for me to ask the 2 questions, do you answer them in whatever fashion you deem appropriate and to move on. I'm not going to add a 3rd or 4th question now. That would be most unwise of me. So let's proceed.
So the opposing party has also health issues. He's threatened to commit suicide. He's threatened to kill Mariah and the child if she ends the relationship. I mean, you can't just make statements like that and get away with it. He was so involved with drugs, he started selling drugs for a drug dealer, right? But then what he did is he got high off his own supply. So everybody knows rule number 1 is don't get high off your own supply, right? Well, that's exactly what he did. Then the drug dealer threatened to kill Mariah and the child in lieu of that drug debt. So Dad has a lot of issues. He can't even handle his own life. He can't even take care of himself. He's been absent from his child's life since July. I mean, if someone truly cares about their child and they're truly taking care of their child, if their child's not in their presence within 1 hour, they're going to do something. They're going to call the police. They're going to call 911. They're going to call the FBI. They're going to call the missing child. They're going to go file a complaint. He didn't do anything because he was partying like a rock star. That's what he thinks. And in fact, Mariah's been hearing from third parties that he continues to do drugs. He doesn't have the issue under control. We want to request today a drug test. I hope it comes out clean, but we want to further request random drug tests during the pendency of this case where Mariah could just request at any time a drug test to make sure this man is no longer consuming drugs. Okay? This man would disappear for days at a time and then show up in the middle of the night, ransack the house, cause drama, invite people over to engage with more drug use. So considering his history of child endangerment, I don't know if Mariah knew that he had the child endangerment charges when she had this child with him. I think she learned about this after the fact. Correct, Mariah? Was it after? Anyways, we can come back to that. So the fact of the matter is, Your Honor, considering his drug use, considering his mental state, he then went to a safe house, but we don't believe it finished. He finished the requirements there. He complained that someone stole his wallet, so he left. So, I mean, this person probably needs years and years of treatment to overcome his issues that took him years and years to develop. It's been Mariah who's been taking care of this child since July, or even before that, actually, because even if they were together, he wasn't actually jointly raising this child. It was always Mariah that was setting time aside to make sure that this child's needs have been met. At this point, she's requesting that she continues to stay in El Paso, Texas, because her and the child have been staying there. She has family there to assist her. It's a better lifestyle. She further did some more research that it's a safe environment. He's not going to be exposed to drugs. He's not going to be exposed to Dad just showing up out of nowhere while he's high. Lower lifestyle, better schools, and that's ultimately what Mariah is looking to do, is to improve her life and the child's life. And she's been there for months. And I'm sorry, Your Honor, I raised my voice at you. Thank you.
It's not that you raised your voice, it's that I don't care about that. I care about the fact that you're not, and the question, and maybe Mr. Schneider can, I'm concerned that the questions, these are basic questions. We can't have it where someone's brains are scrambled and then say, but they gave their meaningful consent.
Listen, on drugs, I can't control.
And then number two, he would,
drugs, then take care. I can't be responsible for the conduct, Honor.
Okay, and I get that, but that's a deflection. That's not what this is
conduct.
about.
He needs to be responsible for that, and I want us to focus more on that. Because if someone scrambled on drugs, they can't take care of a child. That's all I care about. I care about the child.
We'll find out. Here's the problem, though, with the if we have somebody likewise who gave consent, and we're saying, well, and they didn't give their consent. They gave their consent, but they didn't ask what time I'm going to get, and it was understood they'd have no rights except supervised visits. That individual, likewise, if the agreement is when his brains are scrambled, likewise, that is a faulty consent type analysis. And also, he's saying that, and we can find out, he's saying he passed a drug test today, and that he's been through the rehab, and that he didn't, in fact, give consent. He's saying his consent was for her to return in August. Now, does anyone have any emails or communications where they discuss this, or are we supposed to rely on these two people as to what they verbally said? And if I have to rely on that, I'm going to have to make a finding that one of them has a great deal more credibility than the other, and I would have to do that via testimony or something. So does Mr. Schneider, or Ms. Cesar, does anyone have any communications about this?
Mariah has text messages between him and her. I have to And, you know, I'm happy to present those further with the, but listen.
Does he say, yes, move to El Paso with Charlotte, that's fine? Does he say that?
I mean, he said his opposite in his motion, okay? But I have to look at the text messages. It's, you know, I can't go through everyone's.
Motion? No, well, okay, and I understand that, but when did he say it? In what form did he give the consent? What, I don't know, just, okay, Mr. Schneider, if they can find something, they'll
And
find it if you can.
July. If you want to solve all their issues today, but you know, that's difficult to do. She's been there since July. Okay, this is going to have to go to an evidentiary hearing. And
Issues, if someone keeps saying consent, 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 and I say, here's your golden opportunity to prove it, and you say, oh, you judge, you're being picky,
What?
we can get to
A
all that
motion-
later. This is the
What?
case. The case is, A, you said he gave consent, and B, whether he did or not, that he's too adult to care for a child. And then when I ask for evidence which would support either of those, I'm being accused of being hyper technical or picky when I'm going right to the most general issues of the case.
I feel like you're.
Whatever, okay, Mr. Schneider?
Thank you, Your Honor. First of all, my client and Miss Rittman were childhood sweethearts when they were 14. They maintained a relationship when he was in prison. She drove over 500 miles to pick him up.
Motion, Your Honor. So now
I'm
I'm.
not going to interrupt Miss Issa. Would you please mute?
Hold on, I'm sorry, I thought you would complete, were you still presenting?
Yeah,
No, I'm
yes,
just-
Your Honor.
Wait, hold on,
Motion of-
she's interjecting, so, Ms. Issa, were you still presenting, is that the issue, or?
No, the issue is Mr. Schneider is raising things that weren't even in his motion. There's nothing about childhood sweethearts. There's nothing about her visiting a jail. Because if so, I would like
It's
to.
just background material, he's not asking for me to rule on it, he's not asking me to make a finding they were childhood sweethearts, and I won't. He's just providing background, I think, so proceed.
Thank you. Thank you, Your Honor. They were childhood sweethearts. They lived in the same neighborhood. They maintained a relationship while my client was incarcerated. Miss Rittman drove over 500 miles to pick him up from Carson City when he was released. They had a child literally, she got pregnant literally within a day or so of his release from prison. They lived together and they co-parented until 3.5 years later when the child was 3.5. My client didn't get a lot of time to grow up, and he got off the hook a little bit with alcohol, and there was admittedly some cocaine use, and he realized he had a problem. He wanted to maintain this relationship, and he went to rehab, and he's clean and sober now and has been. Now, Miss Rittman wanted to go to Texas temporarily to see her father, and she did, and my client agreed she could go to Texas temporarily. There was nothing in writing, there was no court order, and she took off, and she's been stalling him all of this time, trying to get 6 months under her belt in Texas. Finally, my client comes to see me, and I realize it's pretty clear what's going on, so we file this motion,
Okay.
and they file a motion in Texas. But now that he's-
Someone needs to answer my question if they can. I didn't really, it sounds like from their side that it was mainly verbal, but that they may be able to locate some emails, we'll see. Did your client, was the consent until August, was that confined to verbal, or did it also include email communications?
It was all verbal, Your Honor. There was
Okay.
nothing in
Okay,
writing. There's
well,
nothing.
I don't think either of these parties so far should be assuming that the court imprints either of them with such profound credibility. Not when everything that's dear to them both is at stake. Without evidence or testimony, I can't make findings who's more credible on this issue, and you guys know that. So if it's limited to verbal, therein lies the problem. So was there any sort of if it's limited to verbal, then it is, and Ms. Issa doesn't need to search for this stuff. So, what, you're saying his understanding was that she'd return in August? How specific was that addressed?
Well, Your Honor, there are some communications. She was supposed to return in August, and she just, she moved in with her father, and she just stayed there. And my client was trying to put the
Well,
relationship
you just
back.
passed over that. I mean, what was specific? That's a biggie. Even though both counsels seem to think I'm being picky about the main issue that in fact this is what you both made pretty much the main factual dynamic in dispute. Two things. Number one, that you disagree with them as to his condition and that he's in fact addressing his condition, and number two, this consent issue. And
Right.
for some reason, when I asked Ms. Iso about it, she seems to think I should be focusing on other things. And two, you seem to think we should pass over this quickly. Oh, yeah, it was understood. This is critical.
No,
Exactly what was said and how was it documented. Exactly what were the terms and exactly what was the understanding. I mean, I agree, it doesn't seem to make much sense that someone would have consented, unless she says he's in that condition, and I get that, but that someone ordinarily wouldn't consent unless it's understood. I haven't seen anyone consent, yeah, even though I love my daughter more than my own life, yeah, you can relocate, we'll figure out later what crumbs I get, whether it's supervised visits or nothing. That doesn't seem to make sense unless he really is in the condition that they indicate he is, which I guess is
There's no mental health issues.
so
He never
what was agreed to, and what was specifically said, if that's all we have is verbal communications?
Your Honor, I'll actually let my
And
client
what
answer
was,
the question.
what is his present condition? He's in rehab, can he pass a test, which they require?
He can absolutely pass a drug test, Your Honor. He absolutely can pass a drug test. If that was the alcohol got the better of him, he stopped drinking. He's good to go on that. There's no
All right,
mental health
okay.
issues
What
whatsoever.
was said when she talked about moving to El Paso? What specifically, verbatim, if you can, reconstruct as close as possible, if they didn't reduce any of it to writing, what did he say? I assume he said something about his contact or parenting rights. What was that gonna be? Or he said maybe he didn't, if it was understood she'd return. What was specifically said about her returning in August, and what did she say in response to that?
I'll let my client answer that question now. What was said about her moving to Texas? Go ahead, Jerry.
She was moving to Texas because she couldn't afford living in Vegas with me in rehab. So she went to Texas to live with her father until I got my stuff situated. I went to rehab. I completed it. I have documentation of me completing rehab. She never came
Now,
back.
I would, don't mishmash two separate things. That's an important issue, the rehab, but we're talking about now, what exactly did she say and what exactly did you say about her relocating and when and if she'd return or what?
Relocating was never okay. From immediately, I wanted Charlotte back.
Okay,
she
your
wasn't
paperwork
coming back,
does
so
say you consented, but only till August, so you did consent, right? At least for a month or so.
for a month, but not to live forever.
Okay, so what did you say? Because you just told me you never consented at all, so I'm misunderstanding. What did you say? What did she say, and what did you say? If you want me to ask her the same questions, that's fine, we'll ask. If the attorneys want to question both of you, because I did, that's fine too. What did you?
Yeah,
what did she say, and what did you say? If you get $1 million for approximating the words as close as possible is what you both said. You get really close to it and you could get $1 million. What did she say? What did you say?
She said that Charlotte and then they would come back once I got my stuff
Not
situated.
come back.
Once I got
So far, she's not going anywhere. What did she say?
when she just left when I went to I didn't know
So
she was
she
leaving.
never
She
asked
just left.
about the relocation? Because
No.
for the third
Well-
time, your paperwork said she asked, I consented, but only till August. So what?
I couldn't consent in rehab. I had no other choice while I was
Do you guys
in rehab.
understand that you signed these papers under oath? And I understand a lot of this frustration and lack of focus may be because what Ms. Iso said, everyone's frustrated, including the court, when we're an hour and a half behind, and I get that. But you guys have both said, pounded me over the head with the fact consent or lack thereof is critical, and your condition is critical. Let's put your condition aside for now. But consent is a big focus, if not the main focus of each. It's the main issue, in fact, because they're saying your condition is kind of secondary. If you gave your consent, then it's a done deal. She relocates, and they say your condition justifies supervised visit or whatever, depending on a drug test. So I'll try it for the 5th time. And the record is my friend in this case, because although the attorneys don't seem to be too interested and find this somewhat abrasive, I'm asking these questions designed to the exact theme that they're both hanging their hat on to a large extent. So what did she say about relocating? This is the 5th and final time. What exactly did she say, and what exactly did you say, to the best of your knowledge and recollection?
She said she was coming right back.
I'd be
Okay, we'll
happy to
try for
speak.
6th time. She can't come right back from somewhere that we know nothing about. Or so what did she say?
I went to rehab and she left.
Okay, we'll try it a 7th time.
I'm not.
She presumably asked you that she wanted to relocate somewhere.
She never presumably asked me nothing. She just left. She didn't
Okay.
presumably ask me nothing. She
Okay,
just
so now
left.
we'll try it for
And
an
she said,
8th
"Well,
time.
get my
Why do
child." I
your
had to-
paperwork? And I got you guys. What don't realize is some of my frustration is somewhat justifiable. I know the attorneys don't agree with that, but why would your paperwork then say, I absolutely agree, but it was absolutely understood. It was only for a month till the rehab was completed and she'd be back before the end of August. Now you're saying she never said nothing, she just left.
I'd be happy to speak right if you like.
If someone, here's the problem. If no one wants to, well, they are talking to some extent about the issue of his current condition. And we'll find out, because I am going to order a drug test. And if it's clean, they're going to have to share the child till we have a UCCJA with Texas. But we'll find out first if he's clean, because that's what's the main reason why it said, oh my God, the sky would fall if he had any access because he's on this or that. If he's not on this and that, he's going to have some access. But Mr. Schneider, I think he's. I know that he's overthinking this. He's paying too close attention to what I'm asking. He's thinking there's some sort of traps he needs to avoid. He doesn't really understand. I'm asking it I'm trying to talk like I'm a 10-year-old. So respond to me on a 10-year-old level. Think we're a couple of 10-year-olds. When a 10-year-old says, what did she say and what did he say? That's what it means. It's not, oh, she just left. Or that's not how it's. So respond the way a 10-year-old would. A 10-year-old would not say, she just left or I went into rehab. They would say, okay, here's what she said about moving, and here's what I said. That's all I'm asking.
Judge,
And now I'm being
as I
told it never
understand
came up. Well, the sworn paperwork says, he's saying it absolutely came up. He absolutely consented, but it was very limited. It was just through August. Now I'm being told she just left and never said anything. And what he just said kind of tends to support their position in a troublesome manner.
I know.
Because if he's a bad historian, if she tells me, yes, absolutely, I asked him and here's what he said, here's what I said, and then she says, no, it wasn't to return to August, it was understood I'd be there a while till I got on my feet or whatever, or for an indefinite amount of time, the party who can answer with some degree of specificity, unless they're just really good at recreating, which is possible in retrospect, that party's imbued with more credibility if they can answer a simple question. And I asked him, and if they want her to answer, she'll be given that opportunity. Someone needs to answer this question, or I'm going to tell the Texas judge, I have no idea, because when I kept asking about, because the Texas judge is probably going to want to know. Well, I noticed consent's will want to know. I noticed consent's a big issue here. I'm going to say I agree, but it's really vague to me about what went on because I didn't really extract much direct information from either. And so,
Your Honor, as I understand it, my client went to rehab. Mom left with the child. There was communication after she.
Don't go on, Mr.
Please don't interrupt.
okay, that's fine, but he said, in the paperwork, it said the consent was before she left, but okay, fine, you can qualify it.
The consent continued on after she left. They spoke. He said, when are you coming back? She said, I'll be back in August. And this went on for a while, and she kind of, for lack of a better term, she played him along that she was going to come back. And I believe that there is some communication that we can produce, Judge.
Okay.
But what ended up happening is she finally realized that she had no intention of coming back. And in fact, my client has not seen his daughter but 15 minutes in the last 6 months. Now, he does get daily video
In fairness, because I asked him, Ms. Iso, is she interested in addressing this issue, or would you prefer she doesn't answer the question?
That.
Pardon?
Moving there, she moved. It couldn't make.
Would you like her to address, since he got to address the court, in fairness, does she want that opportunity, or would she rather you just present?
Wants to speak, that's up to her, so
Okay, would you, Mariah, would you prefer to address this, you have the right to address this directly since I asked him. Would you rather, or would you rather just Ms. Easto present your material?
I'd be happy to answer any questions, but Miss Issa
Yeah,
knows the facts as
basically, it
well.
was just that, you heard what he was saying. He was saying, I thought from the paperwork, he's saying he did consent, but only till the end of rehab in August, and you were saying, no, he consented for an indefinite period. Now he's saying that the discussion didn't occur till after you left. So he's saying, once you left with Charlotte, that was the first time there was any discussion about you remaining in El Paso. That's the best I can extract from this. So would you like to, do you recall it a different way? Well, how do you recall it?
Mr. Buck had left the residence and abandoned us and broken up with me already, and had showed up on a Tuesday evening and threatened to kill all of us. And so I asked my father to come and get my child and I for our safety. We left on Sunday, and I told him once we arrived to Texas our location and that we would never be coming back, but he could have visitation as long as he got help and can prove he could be safe, healthy, happy, sober, stable, etc. And I have text messages even as back as September stating that we were never coming back.
Okay. So it looks from what I'm gathering that they're, despite what's in the paperwork, they're both sort of conceding roughly the same thing now. They're saying the dialogue kind of occurred simultaneous or after she left, and she made it clear, I'm not returning. Well, he's saying, well, she said she's returning at the end of my rehab. I'm not sure why she'd go to all that trouble just to relocate for a few weeks, but that's what he's saying. So, since we can't get to the bottom of this consent issue today, I think we need, that's an important issue, but the main issue, by some degree of measure, is what is his condition today? And I believe it's fair to say if he's anywhere near as addled as mom's side indicates he is, he's not going to be, even if he's not going to be able to pass this test, because even if they're saying, oh, sure, you could probably get clean for a week or two, this test is going to backtrack 3-4 months or more, because it'll be the hair follicle test. So I think it's going to tell us most of what we need to know. Does everyone agree on that?
Yes.
Now, if he's clean, the court, whether it's appropriate for the court to jump to a 2 weeks on, 2 weeks off until we're in touch with the Texas court, I don't know. I want to see the drug test first before I indicate whether they should share a straight 50-50 till the relocation and custody is resolved. And even if he is clean, is it necessarily appropriate for a 50-50 based on all this other thematic material that mom's side has presented? I'm not too concerned about a 10-year-old or however old the conviction is, but the current behavior and recent behavior and current condition, and they're indicating there's some explosive or terroristic behavior that might exist independent of drug use but is exacerbated by it. I don't know. So we need to find out some issues. So maybe we should just set a return on the drug test, and if we have a pretty quick return on it, I don't have to get deep into a custodial situation, as long as we agree that until we return in a few weeks, that we allow some significant Skype time, and if you guys have to indicate the exact days and hours, so be it. But we'll send them for a full drug screen. I guess we'll be back, well, we got the family law conference, I assume you're both attending, so probably be back in about mid-March. Let's get that date first, and in the meantime, the court's going to attempt to arrange a UCCJEA, whether it occurs before the next court hearing or not. I don't know. If Texas is interested in asserting jurisdiction and they believe that there's enough connections there, that's fine. We can talk about that. It doesn't seem like a very long period there, but that's fine.
I can do March 13th at 9 a.m.
March 13th at 9. Let's start with that. Is okay with everyone?
Yeah, and we would like some interim, and we would like to put child support in place based off of his calculation. It would come out to $665 a month. Mom just paid $300 registration for the child.
Any support would be is just until custody is resolved. I mean, once custody is resolved, there might be a dramatically different amount for all I know.
665 right now based on numbers on his FDF.
Your Honor, my client has a child covered under his health insurance plan, and again, he's not seeing his daughter. We would like to see the daughter, Judge, as soon as the drug test comes back clean, and it will.
Okay.
Mariah also has to have insurance too
It
because
is unfortunately separate, I mean, unfortunately, it's separate obligations, so they both have to comply, he has to pay, whether it's the full 660, he has to pay something meaningful by the time we return. We're returning in less than a month, so I think that would be the time to set ongoing support until custody is finally resolved, but for now, I would expect them to send it at least 500 till we get back just to cover it, because she does have the sole expense at this point in time. Whether it's a higher, whether 660 is appropriate if she gets full custody or main custody, we'll see. Now, are you both available March 13th at 9, and are your clients available?
I'll make myself available, Your
Okay,
Honor.
who's paying the
I'll make
140?
myself available.
Who's paying the 140 for the drug test? Are we splitting it, or what are we doing? You both have a vested interest in having this test. Do we split the cost? What do we do?
Well, is that order to pay the child
If he's
support?
gonna-
Is it
I'll
going to be
let
ordered
him
on
know.
the?
He'll pay for the drug test and he can credit it off of the support depending on the results. I think that's the easiest. So.
Okay.
Jared will.
And well, can we say the support?
So. Just
Two
on a
months,
temporary
no
basis,
confusion.
500 till the next month, but he can deduct the drug test results. But if it turns out he's dirty, then he has to refund the 140. Okay, so I don't want to get too into support till we start establishing what the important things we need to. So, okay, such as whether it's for a full drug screen. Now, Mr. Schneider, as you know, in this court is huge on just declaring. I tend not to get too upset about things as long as I know in advance. If someone tells me they may fail a drug test, I'll say, okay, thank you for telling me. Let's just monitor the baselines and make sure they're decreasing before we go too far with unimpeded custodial rights. But if someone's going to lie to me about recent and serious drug usage, then the lie becomes the issue, and their interest in bamboozling the system, and that I can't rely on anything that person would say. So I'm just really big in this particular court, candidly more than other courts, maybe more than I should be. I don't know, it's a subjective thing, but the lie becomes the issue. So he's in rehab, and he already knows this. He needs to tell us. There's no criminal exposure to any of this, of course, there's no self-incrimination. So this is, he needs to tell us what he used when he last used it, and that's what they wanna hear in rehab, and that's what we wanna hear, because we wanna hear. So, or more to the point, the most important, is there anything that needs to be declared that will be positive? Because we're going back 4 months on some of this, sometimes 6 months according to recent studies. So what do you think we need to know?
Well, let's ask my client.
6 months. If it goes back as far as 6 months, alcohol and cocaine use. So I went to rehab. But anything since then, nothing besides
We're not going to be able to
marijuana.
detect alcohol back too far more than a day or two, but with a
Oh,
hair
but
follicle
thank you.
test, we can, and with most other matters, urine, blood, saliva, most drugs are out of the system a day or two, but the hair follicle goes back like months, 4 months, so, or more, so what could?
Your Honor, my client will be
Go
clean
ahead.
except for marijuana.
Pardon?
My client will be clean except for occasional marijuana use.
That's not what he just said. Mr. Schneider, please.
I really appreciate it, Ms. Issa would stop over talking myself, the
Because-
court, and everyone else. Your Honor, my client said 6 months ago he
He
used
just-
cocaine. Would you
Okay.
please hush, please?
No, I'm not gonna. No, he just said cocaine within 6
Please
months.
mute her.
Let's find out. I thought he did say, I could be wrong, I thought he said, well, let's find out again. Did you indicate, how recent was the coke usage?
6 months, Your Honor, say it again.
Over 6 months ago, sir, when I went into rehab. 6 months ago, July of 2021.
Okay. How about even though we're not really looking at legality factors here, and we're far less concerned, but if THC does occur and it's at a certain level, it could impede parties' ability to care for a small child. So when's the most recent pot usage? When's that most recent on that?
Probably within a week.
All right. How often? Because,
Not often. On the weekends, you know, after when my work week is over, on the weekends, I'm at home, I'm barbecuing, whatever. Minimal.
are there any prescription drugs? There's any opioids?
No, sir,
anything?
absolutely not.
So what I understand, like Ms. Issa said, we need clarity on this. So are you saying that your last controlled substance by law is cocaine from 6 months ago, or?
Yes, sir. That's exactly what I'm saying.
Okay, guess we'll find out.
Yes,
Okay,
sir.
so, that's where we're at. Continued proceedings for March 13th, but we need the drug test done, like, today.
Okay.
Your Honor, we would also like daily Skype. Or
What do we want to agree on as to that?
Daily is too much. It's kind of intrusive. We were going to suggest Friday night at 8 p.m.
That's fine.
Saturday
Judge,
night
my
at 8
client has
p.m.
been monitoring the crime
I'm speaking.
for the last
And
6 months.
Wednesday night at 8 p.m. Daily is too much for a 4-year-old. Even if that's just too much.
All right.
Every day.
If we do
Yeah,
every
daily's
day,
too
I
much.
think if we do
So-
if we do every day, we're creating.
I'm the one that said he
conflict,
can have
okay?
FaceTime calls. They didn't even
Okay.
ask for that. I'm the one that mentioned it.
We
We were going to suggest three
pick
3 days
two
a
or
week
three
is
days-
good.
Pick 2 or 3 days a week. If we do it once a week isn't enough, and if we do it every day, we're inviting problems. You didn't call. Yes, I did this. It's going to be, or someone wasn't available and has legitimate reasons. So let's
What
pick
time?
pick 3 times, 2 times a week or 3 times a week, and that you can agree
Sunday,
on.
Yeah, Sunday, Wednesday, Friday.
Sunday, Wednesday, Friday, Judge,
At
time?
5 p.m. 6 p.m. her time.
at 6 p.m. Texas time.
Is your client available at that time?
Yeah.
So-
Yeah,
And
Okay,
and Dad
Dad
will
make up? Mom will connect.
no
you
no
want Mom
no
to
Dad
call
has
in
to
or Dad?
initiate the call.
Who?
Dad has to initiate the
Okay.
call because Mom is handling
Okay.
the day-to-day responsibilities.
Okay, and Dad, unless Mom hears Dad saying or doing something inappropriate, she'll afford them reasonable privacy and leave the room. If she hears anything that's a concern, then she can be there. Okay, anything else for today's purpose?
No,
Thank you, Your Honor.
Thank
Thank
you.
you so much.
Thank you
Have a
very
great
much.
day.
We'll see you likewise. We'll see where we're at on March 13th. I hope the test allies a lot of our fears and concerns.
Thank you, Your Honor.
Thanks,
Have a good day.
You too, though.
Bye.
Yeah, bye-bye. Okay, do we have